Hello everyone! Today I would like to talk about humanitarian and compassionate considerations in relationship to immigration to Canada. Sometimes a person is inadmissible to Canada or they do not meet the requirements of immigration to Canada. In those situations, humanitarian and compassionate considerations applications could be an option for those applicants. But let's first see who is inadmissible to Canada. You could be inadmissible to Canada because of security reasons, because of human rights violations, serious criminality, also being a member of a gang or organized criminality, sometimes because of financial matters, medical issues, or even because of another family member. In those situations, you may not apply for immigration to Canada. If you apply for immigration to Canada, then your application will be refused. Some options for inadmissibility, they have a time limit. For example, if somebody is inadmissible to Canada because of misrepresentation, then there is a 60 months ban on them. But automatically after 60 months, they can apply for immigration to Canada. But some inadmissibilities to Canada, they could last for a very, very long time and in theory forever. In those situations, if the person wants to immigrate to Canada, one option could be pursuing humanitarian and compassionate considerations. There are other times that it's not about inadmissibility to Canada, but in fact, it's because you do not quite qualify to immigrate to Canada. For example, you want to sponsor your parents or grandparents to Canada and you do not meet the financial requirements. Or you want to immigrate to Canada as a sponsored spouse, but unfortunately, your sponsor was already being sponsored to Canada in the past 5 years and he or she doesn't qualify as a sponsor to sponsor you. Whether you cannot apply for immigration to Canada because of inadmissibility or not meeting all necessary criteria, you could possibly consider humanitarian and compassionate considerations. However, you need to keep in mind that if inadmissibility is because of security reasons, because of human rights violations, or because of organized criminality, HNC is not an option. Let's talk about the way that you can apply for HNC or humanitarian and compassionate considerations. In fact, the way that you apply depends on where you are right now as the applicant. So if you are inside Canada, then you need to prepare a package for humanitarian and compassionate considerations. There is an actual form for HNC that you need to fill out. And of course, lots of supporting documents that shows that you deserve to be forgiven by the minister or the minister's delegate, which is the immigration officer, to become an immigrant to Canada despite your inadmissibility or not meeting the qualifications. That's a huge package. Then when you prepare the package, as I'm recording this video, you need to submit the package in paper to a visa office in British Columbia called the Backlog Reduction Office. But what about outside Canada? When you are applying to a visa office outside Canada, then you need to prepare your regular immigration application, and inside that application, you need to have a mini package for humanitarian and compassionate considerations. You need to include every single document regarding your humanitarian and compassionate considerations. Can you also use the HNC form? Why not? You can use it, and you need to let the officer know that you are aware that this is an outside Canada application. However, you are filling out the form to give them better ideas about your request. From a legal point of view, the H&C application falls under Section 25 Sub 1 of the Immigration Act. And according to that section of the Act, if your application is inside Canada, the officer must consider your request for H&C. But if your application is outside Canada, the officer may consider your H&C request. In other words, you may submit an application to an outside visa office and they completely ignore your request for H&C. Interestingly enough, for some methods of immigration, requesting H&C is almost not an option. For example, for express entry application, you don't have much of a room to wiggle in terms of humanitarian and compassionate reasons because the application will be processed by computer before even you upload your documents. And if you do not meet the requirements, you will never be able to apply. But there are certain methods of immigration, like for example, the startup visa or like federal self-employed class, that you still may include your H&C requests. But as I mentioned, because these are outside Canada applications, unfortunately, the officer may completely ignore your request under the law. One important issue that you need to know about H&C applications is that unfortunately, H&C applications have very low success rate. Probably roughly around 50% of those applications will be accepted. So unfortunately, many of the applications, even those applications that are sent inside Canada, they will be refused. This is partly because many people use H&C application as their last resort. For example, they apply for refugee class in Canada and their application is refused for refugee, and then they try H&C. In those situations, the chances that those people get accepted is close to 0% in many cases, unless they have very strong reasons and very strong documents that convinces the immigration officer they deserve permanent residency under humanitarian and compassionate considerations. A typical H&C application inside Canada has two stages. Stage number one, which takes a very long time, sometimes 1.5 years or 2 years, is that an officer will review the application to see you deserve humanitarian and compassionate considerations. If they conclude that you deserve that, then some positive things will happen for you. For example, if you have a removal order from Canada, that removal order becomes unenforceable. This means that CBSA or police officers may not remove you from Canada anymore. Also, if you want to apply for a work permit, if you pass the first stage, then you are eligible to submit an application for an open work permit and start working in Canada. However, the time span between stage 1 and stage 2 is usually not that long. The stage 2 includes some more documents from you to make sure that you don't have, for example, medical issues, assuming that your inadmissibility was not for medical reasons, or for example, your background check, other than those areas of inadmissibility that you have already argued and received approval by the minister under humanitarian compassionate considerations. They collect all those documents and then they will approve you if they are convinced that you have no other issues but those that they already exempted you, and you become a permanent resident of Canada. Because this is an inside Canada application, you don't need to leave Canada. You usually can go to an inland office and they will validate your confirmation of permanent residency, or you could consider doing flag polling, or if you wish, you can of course travel outside Canada, and when you come back, they will validate your confirmation of permanent residency. So for outside Canada applications, when you apply, if the officer realizes that you deserve H&C, then they will consider H&C and they will exempt you for those parts of your application that covers the H&C and exempt you. Of course, for the rest of your application, they will consider all the applicable laws, and if they approve you, then they will invite you to travel to Canada and become a permanent resident of Canada. If you do not qualify for H&C application, then there could be some alternatives for you. For example, application for a temporary resident permit, which allows you to enter Canada on a temporary basis. You won't become a permanent resident, but that's an opportunity for you. Also, in some areas of inadmissibility, you sometimes can address the underlying issues. As I mentioned, for example, for misrepresentation, you can wait 5 years and then apply. Or if this is a criminality issue or serious criminality issue, you could potentially apply for rehabilitation, or you be deemed rehabilitated and you don't even need to go through the H&C application process. Keep that in mind. Can you ask an immigration officer to consider humanitarian and compassionate considerations for a temporary application? Let's say you're applying for a work permit or study permit or for a temporary resident visa and you do not quite meet the requirements or you are inadmissible. Can you make those applications? Technically speaking, no, you cannot, because the law does not support that. However, in some soft cases, you could also include H&C request in your application. So let's say, for example, you do not quite meet the financial requirements of a temporary resident visa, but you are also visiting your dying parents in Canada and you really need to be at their deathbed. In those situations, of course, you can explain the situation, and if the officer agrees with you, they will allow you to receive the visa and come to Canada. Having said that, as I mentioned, under the law, there is no specific provision that says that the officer is mandated to consider H&C for temporary visa or temporary status applications. In terms of the documents that you need to submit for an H&C application, consider so many different factors. For example, hardship. The hardship that is bestowed to you because of not being in Canada, or to your family members and loved ones who are already inside Canada and they are separated from you. In other words, the hardship because of separation of family members. We also could look into the hardship in your home country in terms of the difficulties that you are facing if you do not immigrate to Canada. We are not focusing on elements of discrimination or elements of persecution that enables you to apply for refugee in Canada, but the elements of hardship that are outside the scope of refugee applications. Probably the best and strongest arguments are around the best interest of a child. So if there is a child involved into that application, whether that child belongs to the applicant or the child belongs to the sponsors in Canada or in any other shape and form that is directly related to this application, then you could and you have to actually present those arguments to the immigration authorities. If you are already inside Canada, you need to show that your life is established in Canada. You need to show that you have started, for example, doing business in Canada, purchasing a place, you have financial resources, and you have lots of family members that they are part of your circle of life. And of course, if you leave Canada, then you will lose all of those. If you have, for example, children who are born in Canada, that will also help you a lot. And that's part of both your attachment to Canada, establishment in Canada, and the best interest for that child. Another issue that you may consider are medical matters. So for example, if you're suffering from a medical condition that your home country is not capable to provide to you, then you could present that to the immigration authorities as well. The list that I mentioned is neither inclusive nor exclusive. You need to look into all different aspects of your life and this immigration and your family members in Canada, if any, and then try to explain to the officer why all of those together and collectively makes you eligible to be considered for humanitarian and compassionate considerations. At the end of the day, it is at the discretion of the officer to decide whether to approve you or not to approve you. Sometimes a permanent resident of Canada does not meet their residency requirements. In other words, they do not stay in Canada long enough to keep their permanent residency. In those situations, when that permanent resident applies for a PR travel document to Canada, then they could present their humanitarian and compassionate elements of this application, why they were absent from Canada, including the best interest of a child. And if they convince the immigration officer, they will issue them a PR travel document. They can travel to Canada and renew their permanent residency. However, if they lose the case to that visa office outside Canada, an alternative option is to appeal that decision to a division of Immigration Refugee Board of Canada called Immigration Appeal Division and present the same humanitarian and compassionate documents. If they have even more, present more, and hope that the Immigration Appeal Division member or judge will approve their case and will allow them to become again a permanent resident of Canada. In terms of permanent residency HNC, the situation is different, and we do not actually refer to Section 25, but we refer to Section 28 of the Act. Also, if you are a practitioner, you may look into major decisions in terms of immigration to Canada by Supreme Court of Canada, like Baker versus Canada, and especially Kantasamy versus Canada, which is a more recent decision by the Supreme Court of Canada, and it specifically discusses the matter of humanitarian and compassionate considerations. I hope you enjoyed this training video. I have lots of other training videos. Please watch them as well. Please like this video, subscribe to our channel, follow us on Instagram, and share this video with your friends and family members to spread the word. My name is Al Parsai. I'm a regulated Canadian immigration consultant. I am the author of the bestseller book, 88 Tips on Immigration to Canada, and I also teach immigration consulting at Ashton College. Hope to see you soon in other videos.